talk to you about what the Supreme Court is saying. They say they're set to deal with any election petition that will arise out of this year's election in 42 days maximum. According to Justice Jones Doche, chairperson of the Electoral Manual Review Committee, any suit challenging a presidential election will only be allowed from contestants in the election and only against the winner and the Electoral Commission. You may recall that the last election petition dragged on for more than 8 months. Even before we listen to Justice Jones Doche, here is another justice of the Supreme Court, Justice Paul Bafo-Boni, stating that they are recommending that all election petitions are brought 7 days after declaration of the final result by the Electoral Commission.
After carefully evaluating our performance in the 2013 election petition, we decided we will have to make some recommendations. And the procedure, for example, if the idea was to file if the law was that you should file your petition within, let's say, 21 days after the release of the results. Now, you have to file within 7 days. If you look at the law, you will see that the response should also come within a certain period. That has also been cut down. So we do not say that it is even the best, because we will still want to have it done before we will still want to have everything done before the inauguration on the 7th.
Justice Bafo-Boni there. Well, here is Justice Jones Doche, who made this disclosure at the launch of the 4th edition of the Manual on Election Adjudication.
The Supreme Court is proposing that should there be any dispute, it would not go beyond 42 days. And there are major significant changes in the law, in the sense that now if you are interested in pursuing or initiating an presidential election dispute, you must have been a candidate in that election. And you can only sue the one who has been declared as the winner by the EC and the EC. That's all. No political party will be allowed to join the suit. And we propose 30 timelines which will not go beyond 42 days. So these are significant material you find in the content of the manual.
Well, for his part, Chief Justice Kwesi Eni-Yeboah indicated that the readiness of the judiciary to deal with all election-related suits. According to the Chief Justice, members of the judiciary have gone through a series of training to equip them with the requisite knowledge to deal with such matters.
I wish to assure the good people of Ghana of the thoroughness, the professionalism and the patriotism with which we approach and dispense our duties. That will never change. Indeed, as part of our preparation for the 2020 elections, our judges had sufficient training to better improve their capacity in handling disputes that might emerge after these elections. Additionally, justices of the Supreme Court have had to travel to various parts of the country to sensitize judges and magistrates in order that they can approach electoral disputes expeditiously. And I'm hopeful that our judges will bring these added skills to bear in the determination of disputes which may arise after the election.
We're certainly preparing for whatever will happen. I have on the phone lines now a member of the NDC legal team, Abraham Amaliba. Ms. Amaliba, you're welcome. Good afternoon. Hopefully you hear me. Let me also introduce to you my other resource person is the PPP flag bearer, running mate for the flag bearer, Kofi Asamoah Siang. Mr. Asamoah Siang, good afternoon. Hello, can you hear me? Mr. Siang, do you hear me? Mr. Amaliba, do you also hear me?
I can hear you.
Very well. Let me take your initial thoughts or your initial reaction to what members of the Apex Court are saying today about settling electoral disputes. Did you hear them, or do I have to let you know what they said?
If you can summarize, it
okay.
was too
So
faint.
essentially, the point is that they're proposing that instead of the 21 days within which people are able to file any complaint they may have, they're looking at doing so within 7 days. That if you have any complaints, issues to raise, you do that within 7 days. And out of the 7 days, they're also saying that they want to settle such issues within 42 days. You recall that the previous election dispute we had took us, dragged for about almost a year. They're saying if any of such things should come up, they're looking to deal with that in 42 days. But they're also proposing that if you want to file a complaint, you do so within 7 days.
That sounds a little strange to me in terms of the number of days that you are required to put your petition together and to file. If you look at the Constitution, it says clearly that you have 21 days within which to bring your petition to the Supreme Court. Now, if the Apex Court is now saying that you have to do that within 7 days, are they proposing to come with an amendment to the provision of the Constitution that says that you should do that in 21 days? I wasn't at the program, but I thought that that question should have been put out there for them to try to clarify. In the absence of any attempts to, as it were, come out with a constitutional amendment, then it will be difficult for anybody to then say that you would have to bring your petition within 7 days. When Article 64 is clear, which says that you must do so within 21 days after the declaration of the results. So I still would want to find out how this can be done if there's no constitutional amendment.
I mean, you can talk about the constitutional. Anyway, Mr. Maliba, I'll come back to you with my follow-up. But let me bring in Mr. Siao. Mr. Siao, what are your initial thoughts on this?
Well, first of all, I hope you can hear me now.
I do. Please go ahead.
Okay, so first of all, I want to start from where Mr. Maliba ended, because I got the same impression that I heard the words recommendation, proposals, and so on. Because for the provision in Article 64, for anybody to suggest any other procedure or timeline which is inconsistent with that constitutional provision, we have to do that through constitutional amendment, which actually has to go through a referendum, because the entire of Chapter 8, which is the executive chapter in the Constitution, is an entrenched provision. So it is only the people of Ghana who can amend that provision through a referendum. So the Supreme Court cannot, in my view, constitute themselves into Ghanaians and say that they have changed the 21 days period to 7 days. That would be completely unconstitutional.
Okay. Mr. Maliba, let me bring you in on this. Now, the Constitution, essentially the law is made for the people. You talk about the letter and the spirit. These are the people who deal with the law. They interpret the law, and the Supreme Court is what we're talking about now. Perhaps over the period, they've realized that this is the best way to go, which is why they're making this proposal in the book that they launched today. If anybody wants to challenge that, what will be the procedure, you think?
Well, the procedure would be to have a constitutional amendment, and that will also require that you would have to go for a referendum, which is a tall order anyway, as my colleague has indicated that this is an entrenched provision. I think that must have been an oversight on the part of the Chief Justice if he didn't avert his mind to this provision and then made that statement. They are there to interpret the laws. The Supreme Court is not above the Constitution. In fact, the Supreme Court is under the Constitution, and the Supreme Court must conduct its affairs in accordance with the Constitution. So it will be out of place if the Supreme Court decides that they would want to say that 7 days, you must bring your petition within 7 days, when the Constitution, the groom law of the land, says that 21 days. I think after this program, they would have been looking at this provision, and I'm sure they would have said that they've gotten it wrong.
42 days, they say, within which they're looking to deal with any electoral dispute that comes up. That is certainly in the right direction, isn't it? Given that we had 8 months of a dragged electoral dispute or electoral election petition, which the government, which was, at the time, I should say, your party in power, indicated had stalled the nation's development.
It is true that the first presidential election petition ever had in this country traveled as long as 8 months, yes. And if you compare it to our counterparts in Kenya, they had a shorter period. Now, the reason was because we didn't put together rules that will govern any election petition. And so in the absence of those rules, the Supreme Court was left with no choice but to go for a full trial, which includes adducing evidence, and you cannot stampede any lawyer into truncating his cross-examination and all those things. And so I think and I agree that it was so long a period and kept this country on tenterhooks. If they are able to come with rules that would be used to manage how an election petition, particularly under Article 64, would be conducted, that would be fine. And those rules would govern the processes. And if they are able to structure it well, and this must go to the Court of Rules Committee. We have what is called the Court of Rules Committee. If the Court of Rules Committee sit down and look at all these processes, they are able to shorten the length of the trial. Then I agree, and I think that I'm in sync with them to have this done within 42 days. I think that is reasonable for me, yes.
Mr. Sia, if I come to you, my understanding from what I'm reading right now is that the Apex Court has exclusive original jurisdiction in all matters relating to the enforcement or interpretation of the 1992 Constitution. And then it also has supervisory jurisdiction over all other courts in Ghana. This is the court that is making this proposal. They can push through, can they?
No, they cannot. You see, like you read, they are there to interpret and enforce the laws or the Constitution as is written by us, the people of Ghana. So that mandate will not include varying the constitutional provisions that we have it. In fact, if you read Article, the first part of our Constitution, the laws of Ghana, it says that any other law which is inconsistent with the provisions of this Constitution, to the extent of that inconsistency, shall be declared null and void. So even if you come to Article 64(3), where the Supreme Court has power to make the rules, they don't make the rules by sitting in the Supreme Court. They make the rules through a constitutional instrument. And by practice and by constitutional provision, constitutional instrument, which the rules of court that Mr. Maliba was talking about, must be laid before Parliament. So even if those rules had been made by the Rules of Court Committee, it should have been in Parliament. So the first question I was going to ask was, when did these rules or procedure proposed by the justices of the Supreme Court laid before Parliament? Has it matured? Has it passed? Just constituting yourself into a committee to vary clear provisions of the Constitution, because they are actually attacking two fundamental principles laid out in the Constitution. The Constitution says any citizen can file a petition. The Supreme Court says no. You have to be a presidential candidate. That is power you are taking from a citizen of Ghana. The Supreme Court doesn't have that power to take something away from us. And they're also saying that the 21 days must be 7 days. I hope at this stage, their proposals, their recommendations, and if they are not, and they are going to insist on this, I will see it as an attempt to make it difficult for anybody to challenge the regulation.
I see. Is your party in that regard looking to approach the Apex Court with your concerns?
Well, definitely. As the discussion I just started, we need to, I think, at this stage, the Secretary to the Judicial Council must, if you like, give Ghanaians further clarification on what the Justice's comment meant.
Okay. Because
the manual cannot constitute itself into any law. The last time I checked, laws are not passed by manuals that any group of people put together.
Very well. So the indication I'm getting is that you will make such an approach. Mr. Maliba, and already, Mr. Siao, you say that if any such thing should occur, it will be unconstitutional. Mr. Maliba, I believe you agree with that position as well.
No, I think that if the Supreme Court intends to apply all these things that they have proposed in say 2021, if there's a dispute, then I think that it is too late now. I am thinking that these proposals are for the future, particularly the 64.3. That is doable, but you don't have a CI now. Parliament is not sitting now. You can't get the number of days that you want. And so I think that this is looking into the future, but not to apply it in the shortest possible time.
Again, that is what you think. And for Mr. Siao, we heard the judges say, this is our proposal. Mr. Maliba, back to you. Will your party, for example, approach the Apex Court and seek clarification?
I am on the campaign trail. I should have been in that program. I was minuted to be in that program. But I'm with the flag bearer. When I get back, I will convene a legal committee meeting, and then we'll look at the proposal and see what we can put together and present it to the Apex Court.
Okay. I take it that this, apart from being a proposal, is not acceptable to you. Should it be something that is to be enforced?
Well, I am all out for the 42 days period within which the trial must terminate and then judgment given. And I, on my own, would canvass, would agree to that. Okay. But I'm saying also that the time is short. We are not going to have a CI that will mature anytime soon for them to apply it in 2021. And so this can be looked at in future. It is futuristic. Okay. But if the Supreme Court is saying that they are going to apply it now, I beg to differ. That will be a serious breach of the Constitution.
Very well. Thank you very much. We'll see how this story develops finally. And Mr. Siao, I still have you there, I suppose. Do you have any final?
I'm here.
Yeah, any final words as well, yours?
Well, basically, yes. Like Mr. Maliba said, it looks futuristic. It looks like proposal recommendations for future elections and not exactly the 2021, because the rules are not in place, and any attempt that the Supreme Court will make to enforce these laws will be completely unconstitutional and therefore unacceptable.
Mr. Kofi Asamoah Siao there, thank you very much. He is the vice presidential candidate for the PPP. And I had Abraham Maliba, who is a member of the legal team for the opposition NDC as well. Gentlemen, thank you so much for your time, and I wish you all the best on your campaign trail. This is The Pulse with me, Gifty Ando Apia.